Tonight we have our yearly human rights lecture for you. And this lecture, we organize this lecture every year on the occasion of Human Rights Day, which actually is tomorrow, the 10th of December. And on this day, the Universal Declaration of Human Rights was adopted by the United Nations. And tonight we are going to talk about artificial intelligence in relation to human rights. And I'm very, very pleased and also very honored to introduce to you the guest speaker of tonight, and that is Professor Prins. And I would like to thank you for coming to Maastricht. And she will raise some questions like, what does the rise of AI mean for independent and expert jurisdiction? And especially for the role of jurisdiction in protecting our fundamental rights. Professor Prins is a professor of law and information technology at Tilburg University. She is chair of the Scientific Council of Government Policy, de Wetenschappelijke Raad voor het Regeringsbeleid, de WRR. She was awarded the Stevin Premie in 2023, and this is an award by the Dutch Research Council, NWO. And she's a strong advocate for integrating knowledge into policymaking, but also the other way around, for understanding how policymaking works by scientists. She will give a lecture of approximately 1 hour, and immediately after the lecture we have half an hour for a Q&A. So I would like to give the floor to Corinne Prins. Please give her a warm applause.
Thank you, and good evening from me as well. Thank you for the kind introduction. Indeed, I will talk about around an hour on AI, and AI in relation to human rights, of course, given tomorrow, but also the role and responsibilities of the judiciary sector in cherishing, I would like to use that word for now, human rights, fundamental rights, in light of AI. And what I'm going to do is, I have an agenda for the hour. First, I'm going to talk about AI more in general, based on a report that we, as the Scientific Council for Government Policy, published in 2019 on AI. The Scientific Council for Government Policy is an independent council. It's the most prominent strategic advisor of the Dutch government. We're in The Hague at the Buitenhof. So when you exit the Binnenhof, which is no longer possible right now because of the renovation, but we're opposite McDonald's, I always say. So when you're having your burger at McDonald's in The Hague, look at the building opposite you, and that's where we, as a Scientific Council for Government Policy, are housed. What we do is, on the broad spectrum of government policy, publish reports that deal with long-term strategic issues. And we try to translate those issues to current day policy challenges and what to do, the nuts and the bolts to use in addressing a specific problem. AI among them, but also climate change, migration, debts, so the full spectrum of government policy. That's the first part of my talk. Subsequently, I will turn to the impact of AI on human rights, and I will do that by talking a little bit about the European Union AI Act. I'm not going to deal with the Act in its full broadness, but I'm going to touch upon a few issues in relation to fundamental rights. So that's the third point. The second point, the impact on fundamental rights. And then, in the third part, I will link what I've thus far addressed to fundamental rights in relation to the judiciary. Explaining to you that, of course, the judiciary is going to use AI itself, but there's much more to it than just what is often called robo-law. And I will wrap up with a few remarks, also as points for discussion and questioning in the final half hour, role and responsibilities of the judiciary in light of fundamental rights in an era with AI. So that's about what I'm going to do in the next, hour. And I think it's important to just show you my working definition of AI, because just raising a few hands, who of you is dealing in day-to-day practice, either education or work with AI? Quite a few, yeah. So when talking about AI, you can of course see AI as the front of what is to be expected or to be hoped as applications of AI, but what I'm talking about today is the broad. Welcome. Hi. So for me tonight, AI refers to systems that display intelligent behavior by analyzing their environment and taking actions with some degree of autonomy to achieve specific goals. That's my working definition for tonight, which is rather broad. So, first part of my lecture, the report of the Scientific Council for Government Policy, just using as a stepping stone for the further parts of my talk. We were asked by the government to investigate, advise on the role of policy and policy making, responsibility of governments, the Dutch government, in light of AI developments. We're an independent council, meaning that 80% of our work is on topics and subjects that we put on the agenda ourselves, but this was a specific request from the government. And in the talk we had before tonight, I said it's always a challenge for the VAR to think of in what way can we add value to all knowledge, reports, surveys, etc., that's already on the table. So what we did in this report is looking back in history. What we did in our report is relate AI to what we've seen in the past as type of technology that you could see as a system technology, in that it had a systemic effect on society. More than just a simple technology, but a disruptive technology. And of course you can argue here, but what we did is compare it with electricity, compare it with the combustion engine, the steam engine, and thus, in looking back at history, looking at what were the effects of the technology, what more specific was the role of government in the decades that followed the introduction of, for example, electricity. So in looking back on other system technologies, we proposed an agenda for our government on, in Dutch, opgave, missions, on how to deal as a government with AI. And we presented 5, in the English translation, missions. In Dutch it's a better word, opgave. I'm going to very briefly explain them to you. So it's demystification, contextualization, positioning, regulation, and engagement. And I said I'll briefly touch upon all 5, because some of them are important in light of fundamental rights. Almost all of them are important when thinking about fundamental rights and even thinking about roles and responsibilities of the judiciary. So what do we mean by these 5? First, what we see as crucial is demystification. What exactly are we talking about? There's a lot of talk about AI. And I just had a definition for tonight. It could be any other definition, but it's good in talking, and it's important when talking about AI in conversation in parliament, in conversation in businesses, international negotiations, etc., to make clear what are we really talking about. And in looking back at history, we all read the stories about the combustion engine or electricity, what it could do to society from a perspective that mountains were promised of what it could, or frightening stories were presented of what is to be feared. But it's in particular for policymakers and in particular for government, it's crucial to be objective, quote unquote. At least not the frightening stories or the hallelujah stories. The realistic, from this moment in time, the realistic perspective on what are we talking about. Not only in the technology itself, but also the capabilities, the expected capabilities. So demystification for politics, and in particular also parliament, is crucial. Because if you remember in the Netherlands the discussions on Siri or other applications used by the government which had some form of intelligence in it, there was not always in parliament a rather objective discussion. So demystification is the first challenge. And our recommendations in the report are related to the different tasks. So learning is crucial, because being aware of what AI actually offers means that you have to learn. AI wisdom. And that also applies to a university. That also applies to various companies, communities, etc. Learn is crucial. Some sort of what we call AI wisdom. Also among the general public. So task 2, contextualization. And I go a bit more in detail in this one because it's also important in light of fundamental rights. How to make it work. What do we mean here? Take the car and the introduction of the automobile and the car. A car cannot drive without a highway, cannot safely drive without security measures in the car. An airbag, how do you call this in English? Gordels, safety belts, thank you. Brakes, crucial. So, a car cannot drive without gasoline petrol stations along the road. A car cannot drive without, in Dutch, the ANWB. So you have to make it work. Meaning that AI and the development of AI, and as a government stimulating AI, is much more than just the technology. It relates also to data, a data environment, the quality of the data. Archiving on how AI is trained, etc. So, contextualization, how to make it work. And here, I would like to make a point that I'll return to later on, and that is awareness of the role of all supporting technologies. So in talking about AI, in talking about governance of AI, regulating AI, it is also regulating supporting technologies. Technologies that enable us to have it operated. And that is what colleagues of mine who are more involved in the more technical disciplines call computational infrastructure. Is this a term known to some of you here in the audience? Yes? Okay. I wrote it very briefly. So the computational infrastructure is the broad infrastructure, among them cloud services, your mobile phones, that also make AI as a system technology work. So when discussing AI, also from a human rights perspective, and I said I'll return to that later, it's crucial to also talk about your mobile phone, to talk about cloud services, to talk about data being hosted somewhere in a cloud, data being used again for AI training. So the computational infrastructure, how makes it work, makes AI tick. And it's crucial also for a government to be aware of this. So it's much more, again, also than the AI Act when it comes to governing AI and regulating AI. It's also regulating, governing cloud services, having a cloud strategy as a company or as an organization, the university or the government. So, task 2, from technology to use. What we, among others, advise the government is to focus on, if you think of the Netherlands, in using AI for its position in the world, for its competitiveness in the world, you have to think of AI in its context. AI being used in the agriculture sector, AI being used in the health sector. How to make it work in the health sector, how to make it work in the agricultural sector, how to make it work in the economies that we cherish as the Netherlands or any other country around the world. So choose what we call your AI identity. And again, improve and qualify skills. The third, and that's an important one in light of tonight's topic, fundamental rights, human rights, engagement. I refer to the ANWB, which is the Automobile Society in the Netherlands, which is a long history in facilitating the use of cars, in helping out automobiles, drivers, I should say. So who should be involved in the world surrounding AI? And what we noted, at least when it comes to involvement of the government, that strengthening civil society, NGOs, is crucial here, helping them out. And organizing feedback loops. Getting feedback on the use, getting feedback on the implications. So from a monologue to a dialogue as a third task. Of course, no surprise, a task is a regulation. And since the publication of our report, we have, of course, the European AI Act. But as said, there's much more to regulating governance of AI than merely the AI Act. Intellectual property rights, consumer protection, not covered by the AI Act. So what kind of framework is necessary? And what we argue in our report, that it needs to be some sort of whole, broader approach. And in particular from reaction to direction. You're from different countries in Europe and around the world, but what is noteworthy for at least the Netherlands here in the AI debate in light of the European Union is that we are rather passive. We wait. and react, instead of we're on the forefront, and we, being members of parliament, members of the different ministries, being at the table in Brussels, we are rather reactive instead of proactive. So one of the recommendations in our report to the Dutch government, which is also important in light of fundamental rights, come back to that later, is be at the forefront of the discussion and not when it's all settled and written down. And that's an observation that applies to more dossiers than merely the AI Act. We are a rather passive country in this respect. Positioning, a bit less relevant for tonight, but nevertheless I'll share it with you. How do we relate to others globally? We all know, this report was published in 2019, but the world has changed since that time. And we are all aware of the enormous use, the enormous implications of the use of AI on what is happening globally right now. AI is a potential means of power, is a potential means of warfare. Erik Akerboom, an important person in the intelligence world in the Netherlands, a few months ago said, perhaps we're not at war. We, the Netherlands, are not at war in the actual world looking around the physical world, but we are at war in cyber. And AI being used more and more as an instrument here. So, positioning, how to relate to AI in light of other state actors, friends, enemies, but also in light of standardization. At the international arenas, standards are being set when it comes to AI. We need to sit at the table, and we, for tonight, the Netherlands, but any other country as well. China is dominant in setting standards in AI, as well as the United States, of course, but Europe is far behind here. And that relates to competitiveness. So standards, competitiveness is crucial. And it relates to national security, and I've already touched upon that. So how do we position ourselves as a country in the international arena when it comes to AI development, when it comes to use, when it comes to standardization? So we said there needs to be much more effort on AI diplomacy and prepare for new threats. Well, we see how the world changes in this respect since 2019. So that's what I wanted to discuss as a starting point on how I look at AI. Crucial that we tell not a story of mystification. Crucial that we relate it to the broader context than merely the technology. Crucial that we involve stakeholders, NGOs that strive for protection of fundamental rights. Crucial that we discuss regulation from a broader perspective than merely thinking that with the introduction of the AI Act we're done, which is a bit of the impression that I often hear, at least in The Hague. And finally, crucial that we position ourselves in an international setting and that we are aware of our position there, also in light of fundamental rights. So then, that allows me to set the step to AI and fundamental rights and the AI Act. Just a question. Most of you are aware that the European Union issued an AI Act? Yes? Or anyone would like to hear in a few minutes a bit more about the AI Act? Yeah? Okay, very briefly then. The European Union issued, as said, a regulation which has multiple provisions on AI. It does not cover all issues that arise in light of AI. I already said it doesn't deal with intellectual property rights. Who owns a certain application? Who is copyright holder? It does not deal with consumer rights. Your right, my right, in light of AI applications. What it does, it is a risk-based, risk-related regulatory scheme. So what it does is qualify, or at least offer the criteria for a qualification of AI applications along the line of high risk, a bit lower risk, middle risk, very briefly put. So it's a risk-related regulatory regime, with as an end result that certain applications of AI are forbidden, that other applications of AI are not forbidden, but should adhere to a list of criteria. And I will deal with that later, because one of them is a fundamental rights check. And there is a low regime for AI applications that are not really risky or invasive as related to risks. So, I've just briefly written down what the aim of the European Union AI Act is. It is, of course, improving the internal market. Of course, it has as an ambition to set a certain position for Europe in the worldwide development of AI, and thereby improve the internal market in coordination between the different member states. Trustworthy artificial intelligence, crucial, with a high level of protection of health, safety, and fundamental rights. As said, prohibition of certain AI practices, requirements for high risks, transparency rules, well, I've listed it in the sheets, will be distributed afterwards so you can read it. What are the prime ambitions of the European Union with the AI Act, which are multiple, and which are, of course, also sometimes difficult to balance. It's a challenge to balance the different ambitions here. So, as a simple scheme, there are certain unacceptable risks, meaning that these applications are forbidden, such as AI-based social scoring systems, high-risk systems, limited risk, minimal risk. I'm not going to read it out aloud. You see the different levels. With minimal risk AI systems that can be used without restrictions. Well, a prominent example here is spam filters. Yeah. So I'll stick to, for tonight, because I can't touch upon everything, I'll stick to the high-risk AI systems, because they relate to a check on fundamental rights, and that's why I specifically address them. So in Annex 3 of the regulation, you'll find the high-risk systems, and you'll see there law enforcement, migration, asylum, asylum, yes, thank you. Administration of justice, turn to that later on. Biometrics, of course. So you'll see the examples here listed in the annex. Okay, given a application such as the the ones listed in Annex 3, what then are the requirements? And as you see, a fundamental rights impact assessment being one of them. Also conformity assessment, etc. Transparency obligations, human oversight, a long list. It's a rather detailed regulation, which will, I expect, still be debated also for the European Court of Justice in the upcoming years, I expect, because there are a lot of open norms and terms that need to be interpreted. But a fundamental rights impact assessment is required for those organizations and those companies that are going to use the systems, the AI applications listed in Annex 3. And then you'll also find in the regulation what the fundamental rights impact assessment, among others, includes. And I listed merely 3 of the specifications. What needs to be specified, among others, are the specific risks of harm likely to have an impact on natural persons or groups of persons, and a description of the implementation of human oversight and measures taken in the case of the materialization of those risks. So that's a fundamental rights impact assessment. So this is my stepping stone for the core of my presentation tonight. And we've discussed that questions is afterwards in half an hour, but who would like to pose a question for clarification? Just for clarification, not discussion.
Yeah, you mentioned that you thought that Europe was behind in terms of international standard setting for artificial intelligence. But you also gave us a very detailed overview of the AI Act, which I think is a pioneering international instrument. So how can you...
Okay, can I leave this? Because this is, of course, it's a bit clarification, but it's also discussion. Would it be okay if you're the first question after the presentation? Yeah? Okay, if I move on, or anything unclear thus far? Okay. Well, what I'm going to tell you now, talk about now, is, among others, written down in an article I wrote together with Bart-Jan van Ettenkoven, which was the, how do I say that in English? De voorzitter van de afdeling bestuursrechtspraak van de Raad van State. Okay, he was chairing in The Hague the Supreme Administrative Court. And he has a key interest in the use of artificial intelligence in the judiciary. He is one of the key advocates. It's evening. One of the key advocates, and I'll turn to that later as well, to say we, as the judiciary, cannot stay behind in the use of AI. Not only in judging about AI, but also the use of AI. And I make this clear because for me it's always easy from the outside to criticize the judiciary system and say you need to do a bit more with AI, whatever application it is. But this is a crucial and prominent judge who says we cannot stay behind. One of the reasons being public acceptance of the judiciary, faith of the broader society in that the judiciary keeps pace. And of course, perhaps you're all thinking now about robo-law in AI applications that decide on whether or not I committed a crime, yes or no. But a very prominent application that is being piloted right now is the use of ChatGPT in preparing layman's versions of verdicts. And it appears that ChatGPT is perhaps better in performing that task than the judge itself, or in Dutch, the persrechter. So, a rather quote-unquote innocent type of applications. We should debate and discuss these as well, instead of very easily step towards the applications that are, well, propagated already 10, 15 years in, for example, the use of AI in criminal law. Is the judge a computer? Yes or no? So, what I'm going to do is first give you a few examples of international bodies that deal currently with the use of AI in the judiciary. Not only the use itself, but also the criteria for its use. First one, and I'll talk about two. Both of them are doing this under the Council of Europe. The first is the Resource Center on Cyber Justice and AI, and they issued a charter, an ethical charter on the use of artificial intelligence in the judicial system and their environment. It was published 6 years ago. So they listed a few criteria, and I stipulated them here. Respect for fundamental rights, as the design as well as the implementation, non-discrimination, quality, security, transparency, impartiality, fairness, and user in control. 6 years ago, we all look at them, read them, and I think that you agree with me, they are rather obvious. But still, they are rather obvious, but are difficult to implement. Because if you think of quality, what exactly is quality? The challenge is always in the implementation. What is quality in light of an application within the judiciary, which is a specific type of application? What is non-discrimination? What criteria do we pose? And with what criteria do we feed and learn and have AI learn? What type of data are going to be used, yes or no? So it's obvious what's there, but it's so difficult to implement. And the user in control. But perhaps you don't want the user in control from the very beginning of the use of AI in the full workflow of a document within the whole judiciary procedure. From the police agent on the street that fines you, gives you a fine, until the final decision by the Supreme Court in The Hague. It's a workflow, it's a long chain with multiple partners. So where exactly in that chain do you want the user to be in control, the human to be in control, etc.? But this is what is to be expected given the ethical charter. Then there is another group, the Consultative Council of European Judges, which is the judges themselves as an advisory body of the Council of Europe on matters of independence in the judiciary. So it's judges themselves on the table, deliberating and discussing the use of AI, the criterion for the use of AI in the judiciary. And they issued an opinion last year. It is a revised, amended, updated opinion. It's a follow-up from 2011. And I have put a quote on the screen: if justice is perceived, and that was 2011, if justice is perceived by the users as purely technical, without its real and fundamental function, it risks being dehumanized. That was 2011. And it's ever more true now. It's not purely technical. And technology is not neutral. I always say technology does something with relations, with relationships. The use of AI by the government does something with the relationship between a citizen and a government. So we cannot merely see it as a technical instrument. We used a pen, and now we use AI. Nothing specific about it. That's not what is the case. So what the Consultative Council did is they prepared a questionnaire and had the questionnaire filled in by multiple judges around the member states of the Council of Europe. And that was the basis for the preparation of Opinion 26, which is, as said, the amendment of the earlier opinion. And I have written down 3 quotes from Opinion 26, which is last year's opinion, 3 quotes. Also for discussion later on tonight, whether you agree or disagree. The constitutional role of the judiciaries may be undermined. Perhaps, yes, I would agree, but the question then is when and when not. May undermine judicial independence when the judiciary do not have informed and effective input and oversight over it. And interestingly, in the United States, courts, in particular district courts, now require litigants, law firms, to stipulate whether they have used ChatGPT or not. So you're obliged to inform the court in a procedure whether or not the document that you provide to the court is being prepared or facilitated by the use of ChatGPT. For the very reason that the judge wants to know, wants to be informed. Perhaps it's okay that ChatGPT is being used, but I, as a judge, would like to know. And you're required to inform me. And the third one, in the meantime, you've perhaps read it all, the use of AI to assist case management or assist judicial decision-making may lack transparency as to what and how information is used by the technology. So it's about reduced transparency, which brings risks for judicial independence and the legitimacy of the judiciary, both individually and institutionally. So not only at the level of an individual judge, but also the judiciary, the court as a system, the trias, as a crucial pillar within our trias, politica. I did not want to have a full-fledged quotation of what you can find in Consultative Council Opinion 26. For those of you who are interested, you can read it, find it on the internet, but having read it, you will conclude that the judges that have drafted the opinion, based on, as said, the earlier questionnaire, are very reluctant in using AI within the judiciary. if you talk to judges in the Netherlands, and I don't know how it is in other countries, if you talk to judges in the Netherlands, they are really very reluctant in using AI. From ChatGPT, the very easy type of applications, to the type of applications that we think perhaps indeed that's a bit too far. In criminal procedures, for example. You do not want AI to be used for putting people in prison, to decide it on how many years people go to jail. But overall, the sentiment within the Dutch judiciary is reluctant. So, a few remarks about the opinion in relation to the second part of my talk, the AI Act, because this is an interesting one. They qualify the majority of the applications as high risk. But the interesting thing I wanted to share with you is one of the pillars of the European AI Act is oversight. So for example, in Dutch, de Autoriteit Persoonsgegevens, the Data Protection Agency in The Hague is the most prominent organization for oversight and supervision of AI. But what is argued here is that given independence of judges, given independence of our judiciary systems, we cannot have oversight by a government body. And this will be a debate the upcoming years here in the Netherlands, but I expect in various European countries as well. Who is responsible for oversight on AI applications in the judiciary? Is that the judiciary itself, given independence and the argument of independence? Or is it the authority that is responsible for supervision of all other organizations, government bodies, companies? Who of you works in the judiciary? Who is a judge? No? Nobody? Okay. It could be that there was someone who had a very strong feeling about this already.
Maybe an extra layer. You have the judges, and then you have an extra layer of judges, I think.
Yeah, but there is, of course, within the judiciary, there is oversight for many multiple things already. Not only AI related, so why not AI? But, and if you think about the trias politica, reason along that line, think about independence of the judiciary full-fledged, then oversight must be within the judiciary itself. There is an argument there to find. But of course, it's also difficult to have a very isolated type of oversight and all others being under the supervision of the Data Protection Authority. Yeah, but that's a point for discussion still. So, what Bart-Jan van Ettenkoven and I did in the article is, if the judiciary is indeed using AI from very simple type of applications, such as using ChatGPT for layman's versions of a verdict, to rather far-going applications. What then should be a compass? What are the elements of a compass for the judiciary in dealing with AI? And we've listed these. Of course, the core values of the judiciary. We talk about independence, impartiality, integrity, transparency. The right to a fair trial. What is the role of the judiciary here when it uses AI itself? And various professional and quality standards, of course. And then the data And the quality of the data, non-biased, safe, is an element of the compass. And of course, all the AI applications have to abide with the legal framework that we have for all applications, also outside use in the judiciary. So privacy, non-discrimination, and the risk-related requirements in the AI Act. But there is, thus far I've talked about what could be called, or what is in literature sometimes called, or in arguments sometimes called, robo-law. The robot as a judge, simply put. But what I personally think will be much more crucial is sufficient knowledge, also in relation to human rights, on AI itself being used by parties that come before the court. The judge as the deciding factor in a battle between, or a court procedure between the public sector, a public sector organization and a citizen. The toeslagenaffaire. It is crucial that the judiciary has sufficient knowledge. It is crucial that the judiciary knows that there is more to AI than merely the technology, that there is also something like context, quality of data, that there is something such as fair trial. And what does fair trial mean when one of the parties has a prominent lawyer with a big law firm using multiple AI applications in preparing the legal documents, the landsadvocaat, with the other party being an individual citizen. So what's equal arms in an era where AI is being used by the different parties that are before the court? What then is the role of the judge in mitigating here, in trying to strike a balance in the position of the different parties? And that requires the judge, the judiciary, the organization, and the institute as such, the judiciary, to have sufficient knowledge on AI, to know that AI was being used for preparing the legal documents. Also because fundamental rights are at stake, not also, crucial given fundamental rights are at stake. So here is a crucial role for the judiciary. And I find it always, well, striking is a bit too harsh formulated, but I find it striking that when talking about the judiciary and AI, it often relates to robo-law. The judiciary being a actor in using AI itself. But the most prominent role for the judiciary in upholding fundamental rights in an AI era is being there as a deciding body, having sufficient knowledge. So, judiciary as an intervening power. For power, correcting power imbalance, but also for correcting far-reaching concentration of power in the hands of certain companies, for example, big tech, with Chinese companies arriving at the scene. So the judiciary has a crucial role to play in the upcoming years in determining the level playing field for AI and fundamental rights. Discrimination, biases in data, with what data are AI applications being trained. The END uses AI, which is the Immigration Naturalization Office in the Netherlands. It uses AI. So the judiciary has a crucial role to play there, in light of transparency, in light of accountability. So when I think about AI, fundamental rights, and the judiciary, and not as a judge, as a person working in academia, as a person working in The Hague for the Scientific Council of Government Policy. And when I'm thinking about AI in general, I think it's crucial that we think about the role of AI, but also our position and our role and responsibilities in what I would call digital capital. Digital capital being society's ability, formulated it there as being society's ability to expressly and consistently rely on fundamental rights. Inclusion, freedom, tolerance, listed them there. So the ability of our society to offer protection for fundamental rights in an AI era. And that's a complicated challenge. And partly that relates to the European Union AI Act, but it goes beyond there. It says something about our society, about our ability as a society to deal with it in a human-centric manner. And it is my conviction that the judiciary is a crucial player here. Not only in upholding digital capital, but also, I mean, this is a very broad and open term. It is something of a feeling that you can have about the type of future that we would like to have with AI, but also in certain situations without AI. And in directing, steering towards that future, in setting 2 steps forward and 1 step back, in learning, making mistakes, in correcting, in requiring transparency, in requiring accountability, there is, one could say there is only one actor that is legitimatized, I should say, to, in the end, in a case-by-case situation, uphold this. So I think that the role for the judiciary is crucial there. And as I said, merely looking at AI as a technology, as an instrument, is the mistake we should not make. Electricity, it offers us so much in our present-day society, much more than merely light. It offers us the engines of our society, which AI is also offering us in the decades to come. But then, in a way that we all see as, yes, that's the digital capital that we would like to cherish in our society. Thank you.
Thank you for your lecture, Professor Prins. You were promised the first question, so I'll come to you.
Yeah, so this is a very general question. You mentioned at the beginning the importance of being ahead, yes, in terms of thinking about AI and so on, and standard setting. And you said Europe is behind in comparison to the United States and China. But we have the AI Act, which is the first international instrument. You may think it's imperfect, but it's an important first step. So how can you say we're behind the US and China in terms of standard setting?
Yes, you rightly correct me. So when it comes to regulation, you are indeed right to correct me there. So the European way, it is also formulated as the European way in not only AI regulation, but earlier also data protection, etc. The whole package of the European Union in regulating and governing digital technologies is a prominent standard-setting package of package and instrument. But the reason why I perhaps too easily formulate it as such, there's much more to it than regulation. Standards are also technical standards. Standards are technical standards in also the quality of data. Of course, we set the standard in regulation, but there are so many open norms there in the AI Act, for example, but also in the GDPR, that the discussion is subsequently the implementation. And for example, I'll give you the example of the GDPR, which is the Data Protection Directive. Privacy by design. Privacy as code, meaning that in the technology we implement the legal requirements and provisions. That is not being discussed in Brussels. Well, sometimes a bit of it is being discussed in Brussels. But the majority of this is being discussed in standards and standardization organizations, with the lead there in memberships also for China, with the technology being developed in the United States, with Google and the types of organizations that are so-called big tech in a prominent role as when it comes to the technology itself. So regulation is one thing, but the implementation of the regulation is often also a technical thing, much more and more a technical thing, with code being code as law, and that's being done in standard organizations. And there Europe does not play the role that I would like to see it play. At least there is still a world to win.
Any more questions?
Thank you for this really interesting presentation. I have a question about the actors that create these AI systems. So you mentioned how they have an impact on the judiciary and how these systems kind of impact the way the judicial sector works. But in the end, of course, it is not necessarily the judiciary that develops these systems. So my question is, how do we ensure that the who should make the choices that impact the judicial system, and how do we ensure that the democratic principles and the judiciary system how it is today is reflected in how these choices are made and how these AI systems are built?
Yes, and now you mean, with your question, you mean the AI applications being used in the judiciary?
Yes, that's right.
Okay. Yeah, the judiciary has been within the Raad voor de Rechtspraak, which is the organization that heads the courts at a more management level, I should say. The Raad voor de Rechtspraak has a ICT division, and there are quite a few very good people working there, dealing with the issues that you address. So I do have faith there. What I see as risky is that this is the organization working for the judiciary, but often it is a whole chain. The police is part of the chain, but not part of this division. The Openbaar Ministerie, the prosecutor, is not part of this division. So it's partly silos. So the challenge is to work together, to coordinate, to exchange and share knowledge, exchange and share criteria that are used as an instrument to decide on the questions that you pose. So I do see that steps are being set. I think the challenge is coordination, working together, given the AI applications are being used in the whole chain. If I may, I think that, and Bart-Jan van Ettenkoven, this is his position as well. It is not so much a question of awareness knowledge and scrutiny at the level of a division like the one I refer to. It is much more the attitude among the judges themselves. Yeah, needs to be a lot to be done.
Thanks very much. It was very informative. I was just wondering, sort of bring this to life, thinking about judiciary and real life scenarios. I'm just thinking about, in artificial intelligence has been around for quite some time. And then I see you've got like machine learning, which builds on artificial intelligence. So I can see like it studying many historical cases and books of law and like extracting all information and then that information being brought together to make a decision. But what everyone's really excited about nowadays is ChatGPT, which is generative AI, which is the new phenomenon like post 2021. And with that, I just see, where does it end? Because, for example, you submit your request to the court and your defence, which can be consumed by AI and it could be analysed by the judiciary. But then when you get into the courtroom, then you say, like, because we're using AI to ingest documents and make decisions based on documents and laws and things like that, then why aren't we having an oral hearing with ChatGPT, as in a judge asking a defendant a question, defendant answering? But then the thing is, in an oral hearing, the right thing to do in a case is often drawn by the emotion of the subject. So, for example, like if the judge sense something like in the body language or the nervousness of the person in the way they answer the question, the judge will go after that person and then they'll ask questions to get them to draw on their emotions, and the defendant at the moment is completely defenseless in their emotion will carry their answer, and it can actually dictate the way that the case goes. But if you end up having robot judges and robot lawyers defending robot clients, then no one will be convicted of anything. And on the other hand, I was seeing like how it works over here in Maastricht in Anadol. At the moment, they only use paper. It takes you 15 months to get a case seen at the court. I'm just wondering, how realistic is it that these judges will be up for this at all? So yeah, sorry, there's many topics I touched on there, but I just think what would make this more interesting is it could bring it to life, some real examples. Or have you not really thought that through? Is it just merely on a sort of high level academic look at things?
Okay, yeah. Well, the realistic example is that the majority of the documents that you would like to be used by some sort of AI application are still paper-based in the judiciary. So I was indeed sketching a bit of an academic type of picture. The realistic first challenge for the judiciary when using AI is making it digital as such, because all documents are still paper-based documents. So that's challenge one. What Bart-Jan van Ettenkoven and I did in our article is indeed list different realistic applications in light of the AI Act. So what is currently being used in the judiciary and what is not being considered or shall not be considered as our high-risk system, so can be used tomorrow, and what will be applications that will never expectedly be used. And we listed very concrete applications. I had a PhD candidate, she defended her thesis with me on a pilot for when you get a fine for speeding on the highway. It is largely automatically transmitted and decided, some people go to court being fined. These cases are rather standard cases. And what she did is she developed a simple AI application that could facilitate the deciding procedure when people go to court fighting in court a decision by a already digital system for fines for speeding on the highway. So that's a very practical example that is now in a pilot being used. So there are applications in use.
Is that if you've just got a robot saying like if you're more than 40 miles an hour and or you're like and this was the circumstances, these were the conditions and all that, it's just normal deterministic computer, like it's just a computer making a decision based on rules and hard evidence, or is it actually AI? This system is actually learning from the past.
The system she developed was learning from previous cases, from exceptions, etc. Yeah.
And in these cases, there are no judges of flesh and blood needed anymore, or?
Well, there was her end conclusion was that there always needs to be a human in the loop. But part of the part of the trajectory could be done with the AI system. Yes, she developed it with the Hieronymus Bos Academy in Den Bosch with AI experts.
Okay. No more questions. Ah. You, yeah.
Yeah, I'd like you to talk a bit about a very interesting case, I think, which is the Romanian elections, where it turned out, where the court found, the Supreme Court, I think, correct me if my facts are wrong, where the Supreme Court in Romania decided that the elections were not valid because robots were involved in social media to plug the Russian-backed candidate there. People in social media, electing people were bombarded with messages by robots who were not recognized as artificially intelligently created people. Now, the interesting thing for this lecture is that the judiciary in Romania apparently felt competent to judge that this had been the case, that to such an extent that the whole election was invalid because of the use of artificial intelligence in the election process. Is that the sort of thing you're talking about, that judges should be competent to make these judgments?
Yeah, you provide an excellent example. Yes, I can... I don't know what to say. This is an excellent example of fundamental rights. What I could say is that, yes, and that your example makes it clear that when we talk about fundamental rights and AI, we often talk about privacy and non-discrimination. But your example shows that the full spectrum of fundamental rights are to be discussed, researched, and as well as dealt with in the judiciary. So the full spectrum of fundamental rights in free elections, but also in freedom of education. So when judging on AI and AI applications, it is of course about fundamental rights related to privacy. It is of course fundamental rights in light of discrimination, but it's also this. So thank you for the example. Yeah.
Yes, thank you for the lecture. I understand from the EU AI Act, that the EU is organizing something, some kind of framework at EU level. I was wondering if we are going to see in the future, I'm talking about Europe only, and I'm thinking about generally, I have the impression that wherever you go in Europe, talking about the democratic countries in Europe, that we more or less can count on the same kind of level of justice. That's my maybe naive feeling, but that's the idea I have of Europe. But can we imagine that in the future there will be much more difference, many more differences between countries in the AI savvy kind of judicial systems in some countries and others not? Less, or in the speed of justice or in the way things are treated.
Well, one of the reasons why I think that the discussions, deliberations, and the initiatives taken at the Council of Europe are so crucial is to at least try to prevent that we have a digital gap when it comes to AI between certain countries within the Council of Europe, which is broader than the European Union. So discussions and debates in these gremia, fora are crucial. And of course, it partly also depends on, is the judiciary triggered given certain events to acquire knowledge? For example, if you look in the Netherlands, the Raad van State decided in a few cases on AI applications, given the fact that they were used in so-called pasuitspraken, which is the stikstof-related debate. So the Raad van State now has quite some knowledge on AI because they were forced to acquire the knowledge given the case that was presented before them. So I think that there should be some sort of common ground when it comes to AI knowledge within the judiciary, and these organizations facilitate this. But it will also depend on developments in certain countries and how AI savvy is a country in the uptake of AI, yes or no? Or in light of the example you gave, what...
Thank you for the presentation. I would like to start by mentioning that I find it very dystopic that the decision from a human life can be made based on something which is not human. And from this perspective, I was wondering, do the people involved in the judicial system use specific large language models, or do they use just out of the box like ChatGPT, Cloud, or Bloom from Big Science? And being aware of the possibility of hallucinations of these softwares based on also on the data set with which they were trained, are they being specifically trained with some kind of appropriate data, or they are just, again, being used just out of the box as they come? Thank you.
This is a very important question because they are indeed trained. There are training opportunities for judges on AI as part of the overall training of judges on a regular basis. So that's one. There is some structured portfolio on applications, knowledge, etc. But a difficult decision or question is, here is the independence of the individual judge, which has always been a topic of discussion in light of digital technologies. That's not specific for AI. But here, of course, it becomes prominent in light of you mentioned a few examples of what they could use or what they could not use. But the same, I see the same at the universities with tutors using different types of AI applications. So the question is, and within the judiciary there is the issue of independence as a complicating factor, but I think that a crucial discussion for the upcoming period is what is the leeway, what is the room for individuals, individual professionals, given their task, to decide on the applications they're going to use, and what is to be decided by the organization at a more general level, and what are the risks of steering too much or steering not enough here. So what do we want? Yes, or perhaps there are some sort of boundaries within you can opt as an individual professional to use certain applications. But this has been a discussion point in light of digital technologies more in general, but it will be a prominent issue in the upcoming years when it comes to AI, in particular with the easy-to-use applications that we now have. Yeah.
Yeah, thanks for the presentation. Indeed, you mentioned that, or I see, I look at the AI Act more like a framework, right? Which is defining some levels of risk for applications, basically. You were talking about the assessment, but how do you cope with the fact that because of the standards are not determined here, etc., then the assessment of today, tomorrow is not valid anymore? So, are you thinking on using AI, for example, to give those assessments up to speed?
Mm-hmm. Frankly, I haven't given this a thought. So it could, yeah. I would like to hear what you think. I don't know. I haven't thought about it.
I think it makes sense. The thing is that we will be coming into a situation where you are dealing or you are asking artificial intelligence to judge about something that there is very little information available, because it's something that is just defined, right? Mm-hmm. Therefore, yeah, I don't know.
Well, it's a good topic for further research and debate and discussion. Yeah.
Good evening, Professor. Starting with a simple comment, you mentioned about using ChatGPT to translate the judgment, and to my colleague's comment about hallucination in there. There's a danger in there about hallucinating in the judgment and the output. So where are the guardrails in that? The second point, what are the comments about in AI about the auditing and the auditing trail? As AI becomes more and more complicated, the audit you cannot possibly do without a tremendous amount of input. And the third thing, which I'd quite like to bring out as a conversation point, is about, like, in my industry with self-driving vehicles, autonomous vehicles. If AI is being used in those applications, who's the throat to choke should something happen? Who is the liability? The liability question. Mm-hmm. Your thoughts?
Well, these are multiple questions.
Yes. Yes. Sorry, I only got one chance.
Let me start with the third question, because I think it is three questions. That also relates to how were they trained? Who is liable when you decided on from the legal regime? Then we have products liability. And the products liability regime, if to be applied to AI, and we're not certain whether that's indeed the case, yes or no, that has to be decided by the Supreme Court at the European level. But the products liability directive, like the exploding Coca-Cola bottle, it is the producer who is liable. So the one who made the Coca-Cola, not Albert Heijn. So to make it easier for the consumer. So if you argue along that line, it is at least the companies that are in the part of developing training, not the one using it. But whether that will indeed be the line of reasoning for AI, well, there's legal uncertainty there until the moment that the Supreme Court has decided, because this is a European rule. So it has to be the European Court to decide on this. And there has been legal uncertainty for software liability, for example, software in radiation treatment facilities, and it has been a long, long debate. So I expect that the answer to your third question, there's at least legal uncertainty there. Auditing, what was the exact question?
If the requirement is to audit where the judicial system is, if AI starts to be used, generative AI is virtually impossible to audit without an enormous input. How does that work in this scenario?
Yeah, and then you mean input from different actors within the whole chain. I know that within the Raad voor de Rechtspraak, the organization I just referred to, this is among others on the table. There's a research lab from the University of Utrecht who relate to the use of AI in the police part of the framework, and they're also discussing this. Because indeed, it is the combination or things that come together that make it complicated in the audit. But I expect that the judiciary will make a prominent point of its independence in the oversight and accountability debate there. And how that fits in the overall, what the end result will be there, I don't know. That also has something to do with the judiciary is a complicated world because you have the responsibility, accountability of the individual judges, of the courts where a individual judge works. So I live in Brabant, the rechtbank Den Bosch, Brabant West, which is completely different from the Court of Amsterdam. They don't necessarily have to work together. And there is, of course, the Raad voor de Rechtspraak, but which is much more from an organizational perspective, dealing with issues. But there's always tension between the more organizational steering of the Raad voor de Rechtspraak, among others on accountability, I expect, and the individual judge at the Court of Amsterdam or the Supreme Court in Arnhem, which says, no way, this is my thing. So that makes this world complicated in here. And then the hallucination. Yeah, I know that the people working at the division that use ChatGPT for the layman's version of a decision, because that's being done at the Raad voor de Rechtspraak, are very well aware that humans should remain in the loop here. So there's always a check on. It's not ChatGPT has done something and this is the final version.
One last question over here and then we have to end.
Thank you. Thank you very much for the lecture. I have a question, maybe this is simple. What is the status in the Netherlands of the evidences produced by AI systems? For example, police uses 23 algorithms, AI. This is one data from the Court of Audit. In general, government uses 433 AI systems in law enforcement, among others. My Ministry of Justice uses 84, including prosecutors, etc., etc. So this is the long chain of producing some kind of evidences by algorithms. And for example, the case that you presented, speeding on the highway, most probably the evidence is produced by the vision recognition machine learning system, not by human. There is no human behind looking at the plate and saying this is correct or not.
No, that's why
so
people...
what is the status of these evidences according to the doctrine presented by Dutch judges and looking at this kind of cases? Because you presented this case to, in some sense, that AI is fighting AI in the court of justice.
Well, AI is facilitating fighting AI because there's a human in the loop. So it's a facilitating instrument. And of course, your point is right in that over time, perhaps you allow AI to be used more intensely in the whole court proceeding part of the overall system. So the correction mechanism is in the judiciary system itself. Being that the evidentiary value of AI systems and is when it is used, and I as a citizen am presented with purely digital-based evidence or rulings, then I start a procedure. I go to beroepswaar, etc. And it is my expectation that in the end, the Supreme Court, which is the final decisive instance here, I don't see AI being used so intensely there at that level that I, as an individual system, am not given the opportunity that a human is judging on, in the end, on the evidence that is on the table. The question is, of course, then, and that was also the question at the afdeling bestuursrechtspraak with the PAS cases, is that the court didn't understand it. So the court was willing and in a position to judge on it, but it couldn't make sense of it. So what the court then did in two times is put it back on the table, in this case of the government institution, and said, explain this to me by a human. So explain it to me, provide me with sufficient information that I, as a human judge, can decide on this. So that's the case for now. That's the situation for now. So it was pushed back from a critical perspective on we can't make sense of this.
All right, let's end this evening. Thank you so much for your lecture. Thank you for coming to this lecture. Tomorrow we have a lecture by a human rights defender from Congo. He's part of the Shelter City project, so this will be tomorrow. Hope to see you next time at Studenthallen. Please give her an applause.
Thank you.